Thank you, everybody. I appreciate everyone coming out on a rainy night. I want to thank especially Reason Foundation, Smith Family Foundation, and of course, Soho Forum for making all of this possible. And I want to thank Glenn, even though I know he's injured. I'm appreciative of the fact that he decided to soldier on and participate in what I hope is a fun, lively debate. Sure. Can everyone hear me okay? Okay, terrific. All right, with all my thanks aside, my husband said I had to open with a joke. I'm not much of a jokester. Well, I kind of am when I teach class, but so the only one I could come up with was, what did Liz Cheney say when she bumped into Joe Biden?
Pardon me.
Pardon me, thank you. I knew this was an intelligent crowd, so you'd get that one. It was originally, of course, a Gerald Ford, Richard Nixon joke, but I tried to update it. Okay, so since I'm taking the affirmative, I think the first thing I want to say is that there's really nothing particularly remarkable as a matter of constitutional law about the Supreme Court's decision this summer in Trump versus United States. As many of you know, despite the outcry, as many of you know, the court held in the Trump case that presidents are entitled to immunity for so-called official acts, which means acts that they take that fall within their Article II constitutional authority. And the reason I say it's not particularly remarkable is that in 1981, the Supreme Court decided a case called Fitzgerald versus Nixon, or Nixon versus Fitzgerald, depending on what appellate level you're talking about. But that was, almost 25 years ago. And in Fitzgerald, the court dealt with a civil suit. It was a civil suit brought by a guy named Fitzgerald who lost his job in the U.S. Civil Service when President Nixon decided to reorganize his job away, essentially. And so Mr. Fitzgerald filed this civil suit, and he claimed that Nixon had actually really fired him because he didn't like what Mr. Fitzgerald had said about cost overruns in a Department of Defense program. And he had basically been a whistleblower before Congress about these cost overruns. And it went all the way up to the Supreme Court, and the court held that because Mr. Nixon was the president at the time this action had been taken against Mr. Fitzgerald, he was entitled to immunity from the civil suit. And he was entitled to immunity because when Nixon reorganized away Mr. Fitzgerald's job, that was merely an exercise of his executive authority under Article II of the Constitution. So any official act that a president takes that is cloaked with the authority of Article II is immune under Nixon versus Fitzgerald. Now, the Fitzgerald court also gave us a rationale for the immunity, which was, I think, very important to understanding the Trump case this summer. And the rationale, said the Fitzgerald court, was horizontal separation of powers, right? Which is just the division of power between the three branches of the federal government. Article I, the Congress; Article II, the president; Article III, the federal judiciary. And the court further said that there's something unique about the presidency. The presidency has two sort of unique different aspects to it that make that kind of separation of powers-based immunity even more compelling than it might be for the other branches. The first characteristic that the Fitzgerald court focused on was that the presidency is very different, unique from the other branches, because the Constitution vests all executive power in one person, the president, right? And that's very different from the other two branches because the congressional power, as we know, is wielded by 535 members of Congress. The federal judicial power under Article III of the Constitution is wielded by, at least at present, 870 different Article III federal judges. But the executive power, constitutionally speaking, is wielded only by the president alone. And you say to yourself, well, isn't it true that there's a bunch of people that work in the executive branch? Don't they wield executive power too? Well, yes, of course, there's lots and lots of officers of the United States that work for the executive branch as well as regular employees of the executive branch. And I call these people minions because I love Despicable Me. But these minions that work for the president, they don't wield power constitutionally independent of the president. The Supreme Court calls these minions the quote-unquote alter ego of the president. And they are accountable to the president alone as a matter of constitutional law. So despite what a lot of talking heads on TV constantly say, and it drives me crazy, executive agencies and departments are not independent from the president. They carry out executive power on his behalf, and he alone exercises that executive power under the Constitution. Another simple way of putting this is there is no fourth branch of government, right? The second aspect of Fitzgerald that made it decide that the president needed official acts immunity was that not only does the president wield all this power alone, but he has powers under Article 2 that are inherently discretionary and incredibly broad. So, for example, the president has the authority, actually has the duty to faithfully execute all federal laws. And as you know, there's lots of federal laws out there, way too many of them if you look at the US Code. And almost every one of us in this room probably is violating one of those laws at some point, right? And so you have lots and lots of federal laws that affect lots and lots of people, but the president can't execute that law against all of us all the time. He has limited resources that get appropriated through Congress, and with limited resources, he has to exercise what's called prosecutorial discretion and decide, who to prosecute out of all the possible people he could prosecute. That is a highly discretionary thing that makes a lot of people mad sometimes. The president also has the authority to basically do other crazy discretionary things like carry out diplomacy, right? He's our chief diplomat. He conducts foreign affairs, and because we all live in 2024, we know the wild swings that happen from administration to administration in the way those foreign affairs, that diplomacy gets conducted. Again, a very discretionary, very broad power. Think about his power as commander-in-chief of the military, same thing. Incredibly discretionary power, incredibly broad power. So all of these things, especially these two factors, the power is wielded by him alone, and the power is incredibly broad and incredibly discretionary. These two sort of unique things that belong to the president make him, in the words of the Fitzgerald Court, an easily identifiable target for litigation. So people would want to sue him constantly because they were angry about the way that a president exercised his constitutional authority. So it's the very nature of the presidency, in other words, that inherently creates this prospect of never-ending lawsuits against a president based on the manner in which he exercises his constitutional authority. And if we allowed all of these lawsuits to go forward, it would be basically a boon for his opponents. You would give any president's political opponents this incredibly powerful weapon to use against the president, to undermine his presidency, to make sure he was subject to a barrage of constant lawsuits that would distract him essentially from being able to do what he needed to do on behalf of the country. Now, we call this today lawfare, right? It's a word that I don't know about you, but I didn't even know it existed until probably about 5 years ago. But now everybody knows what lawfare is. And even though the Fitzgerald Court didn't use the word lawfare, this is what they're talking about. They're concerned about constant litigation against a president for exercising his constitutional authority that's dangerous to the presidency qua presidency, the presidency itself. Because it would not only sort of undermine and handicap the presidency, but it would be damaging, if you will, to the American people, right? Because we elect a president with the expectation that the president is going to sort of fearlessly and fulsomely carry out his Article 2 constitutional authority on our behalf. Now, like I said, Fitzgerald has been around for 25 years, and nothing's really happened. Like the sky has not fallen. And in fact, 25 years ago, I was in law school. And this was something that nobody thought was a big deal, that the president would have immunity from civil litigation based on his official acts. But somehow there's something about Trump and the Supreme Court deciding this summer to extend that immunity to criminal prosecutions that's caused a lot of people to kind of go cuckoo for Cocoa Puffs. All right, but the whole idea here is that if Fitzgerald holds that there's separation of powers reasons for immunity for official acts against civil suits, then surely there must be similar immunity, the same immunity for official acts that trigger criminal prosecutions. Because if civil suits are too distracting of the presidency, if they sap the presidency of vigor, then surely criminal prosecutions must be even more destructive of separation of powers and the presidency. So that's all the Supreme Court did this summer, simply extended that immunity that it already recognized in Fitzgerald from civil cases to criminal cases. Now, so what we're left with at this point is a president who has this immunity from both civil and criminal liability if he is, in fact, doing something that is an act the Constitution allows him to do. But the important thing to realize is that when a president goes beyond this, when a president acts beyond his constitutional authority, he remains fully legally accountable, right? Think about it this way. The president can and does get sued all the time, right? We know that. I'm a lawyer. I've been involved in some of these cases against the president, all right? Presidents get sued all the time. So what happens in these lawsuits? Well, these lawsuits are brought because the allegation is that the president has exceeded his constitutional authority. And when that happens, if the judiciary agrees that the president has exceeded his authority, they're more than willing and able to rule against the president and hold him within his constitutional bounds. Again, plenty of examples, but I'll just give you a few recent ones. President Biden, on at least 3 occasions I can think of, has been held to have acted beyond his constitutional authority. The first big one was when he imposed a vaccine mandate, a COVID vaccine mandate for non-healthcare workers. Supreme Court struck that down. He imposed a unilateral moratorium on eviction for landlords during COVID. That got struck down by the Supreme Court. And the last one that I can think of is he tried to unilaterally forgive billions and billions of dollars in student loans. And that got struck down. So, you know, it's clear that we're not talking about a president doing something that's a frolic and detour. If he's going on a frolic and detour and it's not constitutional, he's fully accountable through appropriate judicial actions. The other thing to realize, too, is that Congress can hold the president accountable, too, if he acts beyond his constitutional authority. The normal way that Congress does that is through impeachment. Now, the other thing I want you to realize is that now that we kind of know what the immunity is and what it is not, is that it's nothing particularly earth-shattering because the other 2 branches of government get the same immunity. Right? So in 1971, Gravel versus United States, the court held that members of Congress have absolute immunity for official legislative acts, right? And the primary reason why the members of Congress got that was because of the speech and debate clause of Article 1, Section 6. But even in the absence of express constitutional language like that in the speech and debate clause, in 1871, the Supreme Court in a case called Bradley versus Fisher held that separation of powers requires federal judges to have official acts immunity for official judicial acts. Same thing, even federal prosecutors enjoy official acts immunity. The court decided that in 1927 in a case called Yaselli versus Goff. And they reasoned that prosecutorial independence is necessary to the proper functioning of the judicial branch. So that's a separation of powers-based decision as well. So all of these decisions basically are saying that any three of the branches, any officers of the three branches who transgress their constitutional authority can be held accountable, but when they act within their constitutional authority, they are not to be subjected to lawfare. So if you are someone who doesn't like the way, for example, a president or a Congress behaves when exercising their lawful constitutional authority, basically you're trying to litigate against these individuals, but not because they did something they weren't allowed to do. They are allowed to do it. The Constitution allows them to do it. But because you don't like the way, the manner in which they exercise their constitutional authority. And when that happens and you don't like the way they exercise their constitutional authority, the remedies are political. They're not legal. So for example, if Congress passes a law that you don't like, but it's well within their authority, as we know, to pass laws, at least if it falls within the enumerations of Article 1, Section 8, then what's the remedy? Well, you vote the bastards out, right? They don't get reelected. Same thing with federal judges. When federal judges have jurisdiction in a case and they're presiding over a case, but if they engage in sort of unseemly or unethical behavior, right? They're drunk on the bench, and that does happen. Then the remedy is a political one. They can be impeached, right? Because impeachment is inherently a political thing. And presidents should be treated no differently, and they're not now that the Supreme Court has extended this immunity to criminal cases as well as civil. And the final thing I'll say is that a lot of people continually say that, well, immunity places the president above the law. He's above the law. He's a king, right? No, absolutely not. That's absolutely inflammatory rhetoric that has nothing to do with reality. Because the whole point here is that this is separation of powers. This is the Constitution itself upon which immunity is based. It is the very architecture of the Constitution. The idea of not harassing someone who's exercising authority that the Constitution gives them just because you don't like the way in which they've exercised that authority. And because that is the basis for immunity, it's not placing the president above the law. It is an articulation of the law, of the highest law, of constitutional law. And Constitution is the supreme law of the land under the Supremacy Clause. If we allowed a regular statute to trump constitutional law, that'd be turning the Supremacy Clause on its head. And I don't think anybody thinks that would be a good idea. But I'm sure you'll have lots of questions, so I'm going to stop there because I just got a 1-minute warning. So thank you very much.